I have 12 o'clock on the dot. Thank you guys. My name is Andrew Kwan. I'm with the law firm of P.L.L.C, Hauser, Lazarus. Welcome to this free CLE presentation, Florida EDiscovery in the Real World, Preserving and Collecting Client Email for State and Federal Court Litigation. I'd like to thank my firm, P.L.L.C, Hauser, Lazarus, and the managing partner, John P.L.L.C, for presenting this. Today we're going to be talking about the rules regarding preservation of email for discovery in civil litigation, and some of the recent case law, some of the rule amendments, and the bulk of the presentation will be about actually doing this stuff. You can go to a lot of CLA presentations and they'll talk your ear off about the law, they'll talk your ear off about the rules, but they won't actually tell you or show you how to do things. And I think in this area, some hands-on experience, some live demonstrations are helpful because not every attorney is technologically savvy. Not everyone knows, the technology backwards and forwards. So I hope this will be an interesting presentation for everyone. Thank you for attending again. And let's kind of go on with the show. Let's see. Okay, so the first part of this presentation will talk about the preservation obligation in civil litigation. And the obligation is provided in federal court by Federal Rule of Civil Procedure 37, and in Florida State Court by Florida Rule of Civil Procedure 1.380. And we're going to be talking about each of those rules and also the rule amendments governing the rule amendments that have changed those rules and how the case law of interpreting those amendments has changed over time. So you should be seeing Federal Rule of Civil Procedure 37E. I won't read you the rule, but essentially it has two prongs, two components, right? Electronically stored information should be preserved in the anticipation or conduct of litigation. And if that electronically stored information, i.e. an email, is lost, then the court asks, there's two prongs, right? Prong one is, if the loss is unintentional, right? If it's a negligent or a reckless loss, somebody didn't turn off the auto delete function on their email. Somebody routinely deletes email and they just deleted this email before litigation without any intent, to deprive another party of the information's use. Then under subsection 1, if there is prejudice to the other party, then the court may order measures that are no greater than necessary to cure the prejudice. And this kind of establishes a bright line standard. Courts before this rule amendment had been going every which way in terms of sanctioning parties for loss of ESI. And subsection 1 says you can't sanction a party unless they prejudice the other party from losing the information. However, if there is a showing or a finding that the party acted with intent to deprive the other party, then you go to subsection 2. And those sanctions are much more severe. If you can show that the party acted with the intent to deprive, the court may draw an adverse inference, right? You see in the subsection 2A and 2B, the court may instruct the jury that it may or must presume that the information was unfavorable to the party, or in some extreme cases, as we'll see later on, the court may dismiss the action or enter a default judgment. So these rules have been changing for years, right? They change all the time. The latest significant amendment was in 2015. And there was a lot of committee notes. If I showed you all the committee notes, they'd last pages and pages. But I just wanted to give you some of the highlights in terms of what the notes are to the rule amendment. This new rule replaces the 2006 rule, and it specifies the findings necessary to justify sanctions, essentially. And like we saw in the previous slide, I'll just very quickly page over, the findings are split into two categories, right? Subsection 1 dealing with, unintentional or negligent loss of information, and subsection 2 dealing with essentially spoliation, when a party intends to deprive another party of use during litigation. So going back to the excerpted notes, the courts are advised to decide whether and when a duty to preserve arises. There are certain circumstances, essentially, that a court looks at to determine when a party is on notice that litigation is likely, and when a party is on notice that information would be relevant. And I didn't put the rest of the notes here, but the notes say that you shouldn't look at litigation in hindsight, right? You shouldn't apply hindsight bias. It's easy to Monday morning quarterback a party's failure to preserve, because obviously if someone's engaged in a litigation, you can always say, oh, they must have known litigation was likely. But the courts are a little bit more, the courts are cautioned not to be too blinded by hindsight bias. Just the fact that there was a litigation occurred doesn't mean that the party should have anticipated litigation and should have preserved discovery. There are many other notes. I just wanted to go through some examples. Again, the Rule 37E, doesn't call for extraordinary steps to preserve. It only calls for reasonable steps to preserve, as you see in the first part of the rule, right? If electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it. So going back, because the rule only calls for reasonable steps to preserve, it doesn't apply when basically information is lost because the party's reasonable steps don't work, or when a party is asked to take essentially extraordinary measures to preserve data. And you'll see that in some of the case law as we get further on into the presentation. The committee notes specify that, for example, information the party has preserved may be destroyed by events outside the party's control. Natural disasters, a cloud storage service, which we're going to get into, a malign software attack may disrupt a storage system, etc. What I didn't put in this section is the notes also say that in determining whether reasonable steps were done, the court has to look at what risks a party could reasonably anticipate, right? If you know that some email is stored on some 20-year-old hard drive, right, running an old computer and it's going to be scrapped, if you know that, your reasonable steps to preserve might be a little bit more stringent than if you, than for other types of ESI or other email. So it's depends on the circumstances. It depends on what risks you might anticipate. The second quote I have from the notes here, a party may act reasonably by choosing a less costly form of information preservation if it is substantially as effective as more costly forms. But here's the kicker. The lawyer has the responsibility to become familiar with the client's IT systems and digital data, right? So, at bottom, the oversight of the client's preservation falls on counsel, and we're going to see an opinion from Judge Matthewman, which is very pointed in terms of, yes, the lawyer has the obligation under both, ethical rules and the rules of civil procedure to to supervise the client's collection of email, and is derelict in those responsibilities if the lawyer just says, oh, my hands are off, my hands are tied, I'll let the client deal with that. That is not enough. So here's Florida Rule of Civil Procedure 1.30E. We just went over Federal Rule of Civil Procedure 37E, which governs the preservation obligation in federal court. And this is Florida Rule of Civil Procedure 1.380E, which governs the preservation obligation in Florida State Court. If the rule looks the same, congratulations, it is the same. It's the exact same. And you'll see in the committee notes, obviously the Florida rules were amended just last year, 2019. Subdivision E of this rule was amended to make it consistent with Federal Rule of Civil Procedure 37E. So it's the exact same rule. In 2012, they have a little note that I thought was worth sharing in the committee notes. Nevertheless, the good faith requirement in subdivision E should prevent a party from exploiting the routine operation of an IT system to thwart discovery obligations by allowing that operation to destroy information. So this covers the situation where, say your email has an auto delete, or your phone automatically deletes text messages past a certain date, and you know that, and you're anticipating litigation, and you allow that to take place to destroy that information. That may be sanctionable. It depends on whether there was any steps to comply with requests to preserve information or any other agreements between the parties. So we've covered basically federal Rule of Civil Procedure 37, which governs the preservation obligation in federal court. We've covered the Florida Rule of Civil Procedure, which governs the preservation obligation in Florida court. And now I'd like to very quickly take you through some recent cases dealing with the preservation obligation, if I may. The first is Shamrock Incorporated versus Remark, 271 Southern 3rd, 1200. That's a 5th DCA case decided April 26, 2019. Just last year, not more than 15 months ago, although it doesn't seem like in our COVID times. That case involved a non-party or a third party, and the 5th DCA was deciding, well, under what circumstances does a non-party to the litigation have a duty to preserve evidence? Essentially, the appellant, was trying to argue that the non-party should preserve evidence when it knows that there's litigation or anticipates that there might be litigation, and it knows that this evidence might be, might be requested. And the court didn't want to go that far. While it didn't speculate, it didn't have a bright line holding as to, okay, well, under these circumstances, you have to preserve evidence if you're a non-party. It said in that circumstance, in that case, the Shamrock case, the non-party did not have a legal duty. Mere knowledge that litigation could be anticipated was not enough. Essentially, unless you have I think the best practice and the holding from the Shamrock case is, unless you have a discovery request or a subpoena out to that third party, they don't have a duty to preserve evidence, or you as a practitioner should assume they have no duty to preserve evidence because they're a non-party to the litigation. So it's very important. You can either send out a preservation letter to those third parties or send out a subpoena, but the best practice is to do that as early as possible so that you get some sort of something on paper that tells them, hey, I might need this information. Don't destroy it. Don't delete it. And maybe that would, maybe that would take you out of this Shamrock case, which again, decided by the 5th DCA just last year. A lot of this, of course, is federal case law because a lot of these discovery disputes don't make it all the way to the DCA or level. First federal case comes from Judge Goodman. It's a Magistrate Judge Goodman, an opinion, Williford versus Carnival Corporation. And that was a cruise ship case, pretty typical in federal court, where Carnival Corporation had X-ray images there was an injured passenger, and they had X-ray images on a shipboard computer. And they didn't really have a good explanation for why those X-ray images, which were digital, stored as a computer file on the shipboard computer, they didn't have a good explanation for why they couldn't retrieve those images during the litigation. So the court held that the party, Carnival, did not take reasonable steps to preserve that information. The holding is a little muddled if you read the opinion because, there's, it's complicated procedurally. Basically, Judge Goodman gave the plaintiff, suffice it to say, some options in terms of explaining about Carnival's failure. But I do not believe Judge Goodman said, okay, we'll give you an adverse inference or we'll strike any pleadings. So the motion for sanctions was granted to some extent, but it didn't go to the level of, didn't rise to the level of, okay, we're going to sanction you, we're going to strike your pleadings, or we're going to draw an adverse inference. The next case is Romero versus Regions Financial Corp, Regions Bank. This is basically, this is Magistrate Judge Torres, again, last year, and he held that a party's failure to preserve a video recording on an ancillary point of contention did not support sanctions. And this, I believe, was a case involving an employment case, and the video recording was about a meeting between the plaintiff and I think it was a supervisor or some other party representative at the end of the day. And it was kind of it kind of shows that just because you fail to preserve e-discovery, ESI, you still need, as we can page back here, you still need prejudice, right? You still need prejudice to another party. And, Magistrate Judge Torres was saying, well, look, you failed to preserve, but it didn't support sanctions because, even if you failed to preserve, it was such a ancillary point, such a tertiary point that it didn't really cause any prejudice. Moving on to some even more recent cases, we have one from Magistrate Judge Brannon. This is Southern District of Florida, NITV versus Dector Corporation. And in this one, basically there was this is one of the cases where someone essentially intentionally destroyed ESI, and Judge Brannon did drop the hammer, right? No problem dropping the hammer. So you're much more likely to get sanctioned if you fall under prong 2 of either of these rules. So under Federal Rules Civil Procedure 37E2, if there's an intent to deprive, you might get a default judgment, as I believe happened in the NITV case. You might get your pleadings struck. Same thing with, of course, Florida Rules Civil Procedure 1.380E, subsection E2, same thing. If you acted with the intent to deprive the other party of information during the litigation, the court may drop the hammer on you. So that's what happened in this case, Judge Brannon. There were affirmative actions. I believe in this case there was a file shredder. There was literally a search for a quote-unquote file shredder. And when that came out, obviously the magistrate judge is not inclined to show any mercy to the party for failing to preserve ESI. The next case is from Judge Reinhart. And we're blessed in the Southern District of Florida with a lot of great MAG judges who deal with e-discovery all the time, a lot of good experts. So I'm giving you kind of a spectrum of magistrate judges, just so you can get a feel for how each one rules in the cases that are referred to that judge in the federal cases. This case, Organo Gold International versus Aussie Rules Marine Services from Judge Reinhart. In this case, there was an email. It did involve email, and the court said that the failure to produce the responsive emails before the discovery deadline, basically these emails were missed. Eventually they were produced, right? But, so there weren't any sanctions in terms of striking the pleadings or anything harsh. It was unintentional failure to produce. They were eventually produced, these emails, but the judge did award reasonable attorney's fees and costs. So that's another form of sanctions that you're much more likely to get if eventually you get the ESI after pulling some teeth and holding people's feet to the fire. Our final kind of run of cases here. This first case is a Florida 3rd DCA case from October 16, 2019. It's Araujo versus Winn-Dixie Stores, 290 Southern 3rd, 936. Now, this case was interesting. It didn't cite these rules, and that's what you got to be careful of. Sometimes these DCA cases don't cite the actual rule, but it did involve a preservation issue. Okay, so in Araujo versus Winn-Dixie Stores, there was a slip and fall, essentially. There was an incident, and Winn-Dixie had preserved the video 20 minutes before the incident and 20 minutes after the incident, right? So no problem there. They preserved it. The other party said, well, you should have preserved it for an hour before the incident, an hour after the incident, for whatever reason. And the court said, no, 20 minutes was fine. you know, that they had no duty to maintain a video for that long. And again, that goes into, although the court didn't cite the rule, I'm sure, you know, in the court's mind, we're thinking about, you know, what are the reasonable steps to preserve and how much information is really, you know, relevant to the litigation. You know, what prejudice is there? And in Araujo, you know, all you had really was the failure to preserve that extra 40 minutes on the front end and the extra 40 minutes on the back end. And the third DCA said, not good enough. Not good enough for a jury instruction on it. You know, not grounds for reversal. Our final case is a Southern District of Florida case. I should have noted the magistrate judge. It's Magistrate Judge Matthewman. It's EEOC versus M1 5100 Corp. I think that's actually a grocery store, jumbo supermarket. And, you know, Judge Matthewman was talking about exactly what we're talking about here, which is the collection of discovery documents, the self-collection of discovery documents. And this is something a lot of lawyers do. You know, unfortunately, if you don't have the technical expertise and you have a client, you just say, client, oh, you know, what emails might you have? And you allow the client to get them for you. You allow the client to self-collect, in other words. But without supervision or participation by counsel, you know, it's fraught with problems because you're signing off on the discovery responses. You know, you're putting your John Hancock on there and you're certifying that there's been a diligent search and that evidence has been preserved. And Judge Matthewman was not pleased with the self-collection in this case. We're actually doing a Federal Bar Association CLE free for all Federal Bar Association members. Next week, I'm doing one, I'm moderating Judge Matthewman's seminar, and he's going to talk about the ethical duties more, you know, and about how he came out in this EEOC case. I'm talking more about the practical, you know, here in this presentation. Okay, so I've talked, you know, quite a bit about the rules and the law, but let's go to, I think, what everyone's here for, which is how do we do this stuff, right? How do we collect email? How do we preserve it? What does it look like? What does it feel like? So, you know, we're going to concentrate on emails for this presentation. I think maybe in subsequent presentations, I might go over text messages or, you know, social media postings or all the various different forms of ESI, you know, in this world. But for now, let's just focus on email because I think, one, that's still the most prevalent, especially for litigation. And two, I think it's the easiest, frankly, to demonstrate. Preserving a voicemail from a phone is something that even e-discovery vendors have trouble doing. So, you know, it might be difficult to present in a CLE, but I think we can present email preservation and collection. So how do we do it? I've kind of broken it into these steps. These are, you know, you'll see various models. The first step is who has the email, right? Identify the email custodians. And the only way to do that is to interview the client or interview or depose even the person whom you want to request the emails from, okay? So if it's a client interview, I usually call these scoping conferences. I've heard them called as, you know, preservation conferences or various names. You're basically asking the client a few simple questions, right? The simple questions are who might have sent or received the relevant email, right? Identify the custodians, that is the people who possess the email. You know, when did they have it, right? When were they custodians from? You know, who, when, you know, what did they have? Did they have multiple email accounts? Did they have multiple, you know, file servers, or did they have their own device or whatever it is, right? And then, of course, you'd have to ask, you know, kind of the how in terms of, well, what exactly did they have? You know, is it on an iPad? Is it on a Gmail? Is it in your company server or whatever it is? So, you know, in my practice, I won't talk about specific clients, but we deal a lot with individuals. If your practice involves entities representing businesses, or if you're suing businesses, this kind of interview would be done with, hopefully, your client's IT person, you know, your client's, somebody in management who would know, you know, who would be the relevant custodians. Okay, so the first step is the client interview. And the second step is reviewing documents, because often, even the best client, even a well-intentioned client, will not remember, oh, so-and-so secretary was involved, with all these communications because, he was the secretary for our COO, and no emails were sent directly to the COO. They always went through him, being the secretary or the assistant, right? And you'll see that from the document review. And that means that the secretary suddenly becomes a custodian, right? Because if you just get the COO's email account, it won't tell you a lot of things because a lot of the email came through the secretary. So that kind of detail only comes out through a document review. It's something that you need to review emails and review, review other documents to see where the bodies are buried, okay? So the first step is to email the custodians, right? Who has the relevant email that you're looking for? And then the second step really is to identify where those emails are now, all right? The second step can be done, again, just by interviewing the client, or sometimes you're talking with client IT. The first thing here is, where are the devices? A lot of times email for a company is stored on their own server. They'll have a giant server with gigabytes and gigabytes of email information stored on there. Say it's an Outlook server, and you can get the email directly from that. You don't have to go to any third-party storage or whatever it is. Sometimes people have internal messaging or internal databases that are, again, stored on the client's network server. You can go to the client for that. For individual clients, again, the clients we see mostly in my practice, or for an individual person whom you're trying to get email from, dollars to donuts, 99% of the time nowadays in 2020, it'll be on a cloud storage, cloud mail. It'll be a Gmail, right? A Google Mail. It'll be a Yahoo Mail. It'll be a Bell South or a Comcast or whatever. And it won't actually be on the client's device. If you were to forensically image the client's computer or forensically image the client's iPad, you wouldn't get those emails because they're not stored there. They're stored in some faraway server. So of course the question becomes, after you've identified the storage, well, how do you go about preserving something like that? Step 3, preserving email. The first thing is suspending auto-delete. For a lot of services, this isn't an issue. I think for Gmail and Yahoo and most of the webmails, unless you hit their capacity limit, they will not actually delete old emails. But that's something you need to watch out for, right? If your client is running up against some capacity limit and they're worried about, and the service is telling you, oh, we're going to delete some emails, you need to suspend that. You need to make sure that those emails are archived before the auto delete or the capacity issue hits them. So once you've stopped the bleeding, suspending auto delete, the next step is to archive the emails, and you can do that in 2 ways. I have 2 ways. I really should have split the box. The first is natively, through the actual cloud storage solution, through like Gmail's inherent tools for archiving emails. And the second is to actually connect your Outlook or your email program to the webmail, archive it, and then save it as a PST or an MBOX file. And we'll get into those more. And let me just pause here, make sure there aren't any questions. Okay, so there is a Q&A box. I realize I'm going through a lot of content. There is a Q&A box if anybody has any questions, but I'm just going on through. So keeping on with the steps, and I will go to the live demonstration at the end of this presentation here. Collecting email is a whole different thing. Once you've preserved it, right? Once you have the email, then you need to cull it, because at least for an individual client like the ones who we typically see, there's a lot of email that has nothing to do with the litigation. So there's a few ways to cull it without going through a full-blown email by email review and using up paralegal or attorney time on that. The first step you can do is date range, right? Oftentimes there's an incident, whether it's an operative incident that happened, the slip and fall, criminal case, whatever, there's only a certain date range of emails that might be relevant. So you block it off by date range. And then the next way to do it is by sender and recipient. So you know only emails from the guy's wife or the guy's girlfriend or emails from this division of the company are relevant. So you can start filtering them by, well, we only want emails that were sent to or received from those particular people, okay? And finally, the third way to do it is by subject matter. And really when I say subject matter, I mean, you can use the subject lines of the emails. You can do a keyword search for certain particular subject matters. It's hard to cull emails that way. I have it here unless you have a very particular subject matter that you're looking for and you can easily cull. Otherwise, that's sort of more of a keyword search issue, which we'll get into maybe in a later presentation or a different day. I just wanted to briefly introduce ways to cull the email. And why culling email is important is if you were to take the average person's Gmail and just upload it to some vendor, or even if you were to look at it yourself, it'd take years, right? It'd take more time than is worth. You really need to cull it before you upload it and process it, okay? And then, which brings us to the next step, processing email. When you process email, you have a few options. You can do it yourself. You can use a third-party vendor, and we'll go over those in just a minute. But when you use a third-party vendor, typically you would literally take the emails that you have preserved and culled in the prior steps and upload it to them, and they have their software basically unpack that email. They would process it in a way that can be used in litigation. So if an email has an attachment, they would make sure the attachment is printed out or the attachment is shown and Bates label that, right? Or if an email has a particular string or a native file that needs to be preserved, they would make sure to preserve that. So again, that's something you can do with some DIY software, which I'm going to show, or that's something that a third-party vendor can do at a substantial charge. And the final step in the processing portion is a quality control review, right? You have the processed email, but just because you uploaded it to the vendor or just because you did it yourself and processed it, you need to make sure that what went out, was what you intended, garbage in, garbage out. You have to do some quality control to review the processed email. So that's kind of the general gist. Here are some of the options for doing it: client, third-party, vendor, and DIY. The first option is using your client to do it. I have had cases, I won't name any names, but I have had some instances where the client was sophisticated enough to actually collect and preserve email. If your client has some kind of compliance, with regulatory compliance, oftentimes they will be familiar with this process. So the pros are the client internalizes that cost. You don't need to really have any expertise in their email system or preserving it, aside from supervising them. The cons are it's extremely risky if your client is not sophisticated. I would never have clients self-collect email where they were not, some institution or some firm that regularly does it as a matter of, as a regular business practice. It's extremely risky. So those are kind of the pros and cons. This is not something that'll come up very often, I think. Much more, common is using a third-party e-discovery vendor. And there's a ton of them, the Florida bar, the federal bar. There's a lot of recommendations on who's good, and you can ask around, ask other firms who they like using. The pros with using a third-party e-discovery vendor are you don't really need to know the nitty-gritty. You don't need to know, how does this email unpack into a native file, and how does it, are there any problems with OCRing that email and all those technical details? You don't really need to know that because they take care of it. And you're not involved in it, so you don't become accountable for any problems with, processing the e-discovery, right? Those are big pros. The cons are that's very expensive. Most of them charge you by the gigabyte. Most of them also charge you for tech time, as they call it, when they have their own personnel, work on your case and work on your, matter. They charge you hourly, right? 150 bucks an hour, 200 bucks an hour. And maybe for the gigabyte charge, they charge you 10 bucks a gigabyte and 20 bucks a gigabyte, to just process it. And maybe the processing is an additional 200 bucks a gigabyte. It can get really expensive really fast. And sometimes, you don't have control. If the e-discovery vendor is having personnel issues, if they have a lot of personnel turnover, if their servers aren't working, then all of a sudden you can't meet your production deadlines and it becomes a huge problem. So, those are the cons. I've used lots and lots of e-discovery vendors. Some are better than others. Some get worse as time goes on. Some get better as time goes on. But, you should be aware of the pros and cons. Finally, there's the DIY approach. This approach is basically where, you handle it, you as counsel. So your client it presents you, hey, I'm a client, I have this Gmail account, lawyer, help me out. And instead of you going to some e-discovery vendor or you, God forbid, allowing the client to try and preserve that email, you go ahead and do it. Your staff, your paralegals or assistants, you go ahead and do it. The pros to the DIY approach, as I will call it, are it's fast, right? It works as fast as you do. So, I know lawyer hours, it'll work. If you're willing to work, you can have it as fast as possible. It's cheap because oftentimes you only have to pay for a software to process the emails. You won't have to actually pay for another warm body to do all this work because you'll be internalizing it. And, you and your staff will have direct control of the client email processing and production, right? Those are huge pros to this process. It means that, you're allowing yourself to take control and prevent a lot of the problems with using a third-party vendor or with the client doing it themselves. The cons require some know-how, right? Not every lawyer has the technical expertise to do it. You won't have anybody any shoulder to cry on. You won't have any outside support aside from, what your e-discovery processing service allows. And this may not work very well for large email sets. So if your client has, a huge amount of email, or if you have 10 custodians in a company, you may want to rethink using a lawyer and paralegal to do that work, right? Because maybe it's better handled by a professional. Maybe it's better handled by someone who does it all the time, day in, day out. It's inefficient for a large email set, in my opinion. Maybe if you're a huge firm, you have in-house resources that can handle that. But the DIY approach, I believe, is best suited for, I have a client, has a Gmail or webmail I need to preserve. I don't want to spend 10 grand preserving it. How do I do it, responsibly, defensively, in a way that will hold up in court and in a way that gets the opposing party what they really need? And to that end, I would like to go to the live demonstration. All right. So here's a client, and the client has a Yahoo email account that has relevant emails inside of it. How do you go about preserving the email? How do you go about collecting it? And I will stop the share at this point. Hi, guys. I'm going to stop the share and go to the live demonstration bit. If you could just please bear with me. Sorry. Okay, so you should be seeing a Yahoo, typical Yahoo mail account, and I'll click mail here. This is a Yahoo mail that millions of people have. Gmail is kind of similar. So you're confronted with this, right? And say this is the universe of mail that your client wants, that you need to preserve. if a client were to preserve it, there's problems. And here, I'll just go over some of the issues, right? So the most naive way to preserve this would be, okay, let's just print out these emails. And I've literally seen, I won't name any names, but I've seen opposing counsel just print out emails. There's a problem with printing out emails. So if you go to, for example, this email, this is an email I sent. If you were to do this yourself, right, say you hit print, right, in the naivest way possible, you print it, and you have a nice little PDF, you know, right, and I'll just save it to my desktop. Right, here's what it looks like. Okay, here's what it looks like, right? Look at this case, right? Interesting case, please see attached, all that. But it's only one page. It's only one page because it's a printed out email. The problem here is if you look at the Yahoo, and I'll share it back with you. If you look at the Yahoo, there's an attachment to that first email. It's a case, you know, I'll preview it right here. This attachment was not preserved just by printing it, and it could be a very vital attachment. Say this is a contract, or say this is some, you know, some message that you really needed to look at. Okay, so that was not preserved. So that's a big problem, attachments. Another thing that a lot of people don't know how to handle is here. Right, I had my my legal assistant, send me this this file. Again, if you were just naively hit print, right, it just gives you a PDF, and it doesn't actually. If I were to save it on my desktop, and let me stop the share, and again share the same thing with you. All right, here we go. We have a nice printout. Okay. Let's see. Does it play? No. It's just an image. It's just an image of the actual audio file. Okay. So it didn't preserve that information. And say this audio file is the smoking gun voicemail, or it's a recording of the defendant, right? That you really need. You don't have it because it wasn't preserved properly. All right. Let's go back to the Yahoo. And of course, there is a more basic problem, which is a lot of times people just look at their inbox or something, you know, some selected email box. Well, what about all the rest of this stuff? What about the trash? Oh, wait a second. There's something here. You are receiving notice of something critical, right? If your client fails to collect, or if you failed to collect this in the this trash folder, you're in serious trouble. You know, so that is something. It exists. That was apparently put in the trash, but it's still there. You need to produce it if it's relevant, and et cetera, et cetera. So those are some of the kind of the perils of self-collection. One last peril here is this. This is an email attaching an email that, again, I received from my legal assistant. If we were to, if we were to print this out, it's the same thing. The email attachment would not actually be preserved, right? The email attachment says something. Let me just save here. Right, if you see here, my legal assistant emailed me an attachment here that has untitled and this parking file, and they're not reflected on this email. So that is a problem with self-collection. I just wanted to go through some of the hazards. And you're asking me, well, okay, how do we do it right? And the first way to do it is with a native a native archiving system. So I'm going to demonstrate that with the Gmail. So this is something I'm going to use my own Gmail for. Let me just, I'm going to hazard this. Let's see here. Okay, so here's my own Gmail, right? And if I want to do this native within Gmail, there is a way to preserve it. If you go to the account system right here, this Google account, you see my, my ugly mug here in the top right. If you press it and there's a box that pops up, I'm not sure if you're seeing it, manage your Google account. So now this is my Google account. And if you go to the data and personalization tab right here, right there, then you have a lot of options for your data and personalization. What's relevant for a litigator is this, this thing right here, download your data, right? Download, delete, or make a plan for your data. You just click that, download your data. And this allows you to export, data from your Google account. And what we're probably concerned about in most cases, and there's a ton of things, but it's mail, right? If you go down to mail, blah, 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 mail. So this allows you to, preserve your Gmail. So I'm going to deselect all of this, just select mail. Okay. And you can select even what data you want included. You can include all the messages, or you can include just specific folders. I'm going to include all the messages, and it tells you what formats it's going to be output in. This one outputs it in an mbox format, which is basically the Unix version of an Outlook PST. Think of it as a giant zip file that contains a bunch of emails within it, or a giant container file that contains a bunch of emails within it. But the point is you can preserve it. So you just click that button, select the data to include, and then you go to the next step. And then you can select a download link. You can send a download link via email. You can do various things, and you can export it. You can specify, and then you basically just create an export right here. Just click Create Export. Right? And it'll take a while. So it'll show export progress, but depending on the size of your Gmail account, it'll take a while to export it. But once it's done, you'll receive an email and you can download. And that will allow you to preserve, again, through Gmail without any, without any problems, just very simply preserve email for litigation. So that's a simple way to preserve Gmail. Of course, some programs like your Yahoo do not have a native export capability, right? That Yahoo that I just was on actually has a very complex method, and I'm just going to very briefly go through it. Let me see if I can do a share. Okay, so say you have a a webmail service, a Yahoo mail service that does not have a method of producing it. So what you can do is, I go to my home, and I very briefly have to all right, so the way you do it in Yahoo is they don't have a method for exporting, their email information natively. You have to basically generate an app password here at the bottom, right? And you have to select an app. Say it's your Outlook for desktop, and you generate an app password. And what this allows you to do is connect your Outlook app, right, to your Yahoo account and download all those messages into your Outlook application or into whatever application. And then you can save a copy of all those emails onto your desktop. It's a little complex. I think it's better. I'm not sure if I want to demonstrate it live here. Let me see if I can. say we have this app password, right? Okay, we would actually take our I really can't. Here we go. Okay, you'd actually take your Yahoo, your Outlook. You go to File, and I think you would add an account. Let's see here. Come on. Not this one. Yeah, you would have to add the account. You would be aquantest@yahoo.com, right? And there's some options here. Connect it. Oh, it's already been added. I think I've already done this for the test. But in any event, the general process is you generate an app password through your Yahoo or whatever service. You connect that app to the webmail. You download the messages, and then you save that on your local machine, and that saves a copy. So that's kind of a quick and dirty way of doing it. Let me just go through here. Okay, so that's kind of our live demonstration. We went over very briefly archiving a Gmail account, and then the general process for archiving a webmail account that does not have a built-in way to save your messages. The general process is, you generate an app password, or you log into your webmail. You connect that to your Outlook or whatever local email service you have. You download the messages, and then you save a copy to your machine. The final thing here is the conclusion. I want to thank everyone for attending. I'm looking to see if there's any questions. If anybody has any, you can go ahead and put them in your Q&A box. I think if you do, let me just see here. Do I see them? No. So yeah, in your Q&A box, if anyone has any questions, go ahead and ask them. I just want to conclude by saying that this is important because pretty much every case nowadays involves email, right? The question I have is, did your client or did the relevant person use email to send or receive relevant communications? And in most cases in 2020, that is going to be the case. Oh, maybe I have something on the chat. All right. Okay. Thanks, Cheryl. Thanks, Ori. No, I appreciate your thoughts. Thank you so much. I do appreciate it. So the question is, did your client or did the person who's relevant, whether it's a witness or whatever, use email to send or receive relevant communications? In 2020, the answer is always yes, almost. So you really have to get familiar, at least if you're not going to do all this stuff yourself, at least how it's done and how a third-party vendor would do it. Certainly don't let your client do it. Part of it is staying up to date on the rules, the case law, and the technology. As you can see, the rules have changed within the past 5 years, within the past year, and the cases go all over the map, right? Depending on the circumstances, depending on the magistrate judge you draw, depending on whether it's a non-party or a party, or whether it's an email, or whether it's archived and difficult to archive. There's a million things that impact it. You have to stay up to date on all that. I want to thank again everyone for attending, and I want to thank my managing partner, John Pankowski, and my entire firm, Pankowski Hauser Lazarus, for letting me present this kind of thing. We have a Florida Bar CLE course reference number, 2005-812N, for everyone who suffered through this presentation. You know, and again, if you have any questions, just go ahead and email me at andrew@phflorida.com. That's Papa Hotel Florida, FLORIDA.com. Yeah, I don't see any questions in the Zoom webinar chat. Again, thanks, Cheryl. Thanks, Ori. You know, thank you guys for attending. I appreciate it.